competence, and credibility. Hoodlums in robes, it's not whether you know the law, but whether you know the judge, are phrases mouthed not just by legal practitioners, but by non-lawyers as well. With due respect to the honest and hard-working employees in the Philippine legal system, unfortunately, you have become the exception rather than the general rule. Congestion of court dockets and delay in deciding cases are kindred problems. 25 years ago, a legal command was made as follows. The Supreme Court shall, within 1 year after the ratification of this Constitution, adopt a systematic plan to expedite the decision or resolution of cases or matters pending in the Supreme Court or the lower courts prior to the effectivity of this Constitution. This command is contained in Article 18, Section 12 of the Transitory Provisions. In this regard, the latest figures as contained in the 2010 Supreme Court Annual Report show that the average disposition rate for all the courts for the entire judiciary is 39%. In other words, more than 60% of pending cases were not decided. It is quite apparent then that what has happened to that 25-year-old constitutional directive? Not much. I shudder when I think about the financial and economic repercussions that all this delay and congestion have caused. Unlike in the US and other developed countries, where top law school graduates vie for limited judicial clerkships, in the Philippines, the beeline is with the top Makati law firms. We all know that any agency, be it in the private or the public sector, is as good as the people who are in it. Hence, there must be a concerted effort on the part of the Supreme Court to hire and keep the best and brightest lawyers within the judicial ranks. On credibility, yes, the Supreme Court has the final say on what the Constitution and other laws mean, and that we are all duty-bound to obey its rulings. But the court should never forget that it remains accountable to the people and to the higher court of public opinion. Decisions that are perceived to be manifestly wrong, obtained through political, financial, or fraternal influence, or that flip-flop, chip away at the very credibility upon which the court ultimately anchors its authority upon. It is only right that if we identify challenges, we must also proactively propose solutions. To address the issues of corruption and competence, the first thing the Supreme Court should do is to mount an aggressive campaign to recruit the best and brightest lawyers and law students. This should be done fully realizing that its work is only as good as the people who do them. Towards this end, the three branches of government should work hand in hand to improve the compensation packages, equipment and tools, and court infrastructure, taking into account the workloads of judges, as well as the physical and reputational risk that their position entails.
Excuse me, Dean, can you now wind up?
Okay, Mr. Justice, just a few more minutes. Let me just go then. Well, I have a slew of solutions which perhaps can be asked later, but maybe just as a final statement before I am asked questions, I would like to say that really, to maintain and enhance its credibility, the Supreme Court should lead by example. It should wipe out its own backlog. It should be more transparent and accountable in the use of public funds. It's about time that the gods of Faura realize that they are more human and less divine. Every year, it should let the public know what its goals, objectives, and key results areas are. Thereafter, it should perhaps hold its own State of the Judiciary address and report on its performance. In short, the Supreme Court should exhibit not just political but judicial will in creating a justice system that we can all be proud of. These are my initial thoughts on the challenges facing our legal system. I have a few more, but I do not wish to abuse the time given by the council. Mr. Presiding Officer, I'm now ready for recitation.
Okay, Attorney Cayusa, you want to remain standing? Can you endure more than an hour of standing with all the questions propounded to you, Dean? Or this time you'll be more comfortable sitting?
No, perhaps I will just remain standing. Well, I will try to endure as best as I can, sir.
Okay. Attorney Cayusa then.
Thank you, Mr. Chairman. Before I propound my question, Mr. Chairman, may I just state for the record and disclose that I have known Chairman Bautista personally since the 1980s, when we both served under the Office of the Chief Justice, and that he was legal counsel of my father's campaign, and he is a personal friend, as I stated. Now, may I proceed with my questions? Chairman Bautista, in the recent forum, and you reiterated today, you presented the pressing need for judicial reforms. In fact, you characterize our present justice system as inefficient, ineffective, and inadequate. What have you personally accomplished in your private or career life, public career rather, particularly as PCGG chairman, that would show that you have what it takes to head the Supreme Court, lead the branch toward the much-needed reforms, and to address the problems of inefficiency, inadequacy, and ineffectiveness?
Thank you very much for that question, Attorney Cayusa. You know, in fact, I've now been with the PCGG for close to 2 years, and I can say that the problems that we encountered coming in mirror the problems that are now facing our judicial system. That when we came in, the PCGG was ineffective, it was inefficient, and it was inadequate. So what we immediately did was we had to restore the credibility of the institution, because that was a main issue, that the very integrity of its creation was being questioned. Its past performance and track record was always being scrutinized. So what we did was that, first of all, I was very fortunate that I was able to convince like-minded, like-valued, and like-principled people to join me in the crusade. And the President was kind enough to appoint them. Second, again, we had to increase transparency and accountability in the way we did things. After all, our name is the Presidential Commission on Good Government. So we had to lead by example. So towards that end, we immediately revamped our website. We came out with a 100-day report. We also came out recently with a milestone report. So we have been proactively speaking with and receiving feedback from our stakeholders, including other government agencies, coconut farmers, human rights victims, the media, and the general public. So in this respect, I think that the situation is similar, although, of course, the PCGG is a microcosm of the bigger problems involving our judicial system. One thing I would also like to say is that really when we came in, we've noticed that there are many faults that we found in the PCGG, and I must say some of these faults can be traced also to the problems of our judicial system. We still have a backlog of 276 cases, and this is after 26 years of existence. Just by way of an anecdote, we have 101 cases pending with the Sandigan Bayan. And out of those 101 cases, well, the average length of time that these cases have been pending is 20 years, with the longest being 25 years. 64% of those 101 cases are more than 20 years old. So we have issues there. We have also issues with respect to the Supreme Court insofar as our pending cases. Out of 65 cases, I think that the average period that it is pending in the Supreme Court is 9 years, and the longest being 21 years. So again, this is something that we hope that we can get some closure on, and that's why we have been filing motions for early resolution with both courts. Thank you.
Thank you, Chairman Bautista. Now, you